big loss.
Oh, thank you.
I'm gonna go ahead and
Ready?
record. I'm gonna do the record now. All right, we're all set.
Call the meeting to order. Can we have roll call, Kelly?
No, I am.
Okay.
Okay.
Roll call.
Mr. Frank Valley,
There.
Miss Janice Warner,
Here.
Miss Dana Gamblin, Mr. Gary Gundelsberger,
Here.
Miss Sharon Johnson.
Here,
We'll have sworn in of anyone that's going to testify today. Amanda?
If you wish to give testimony, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, say I do.
I do.
Thank you. Can we have approval of the previous minutes from February 23rd? Is there any additions or corrections before the approval?
So moved. Need a
Any
motion?
motion?
So moved.
Second.
I have a motion, a second on the floor. Any discussion? All in favor signify by saying aye.
Aye.
Opposed? Motion carried. Now moving to old business. Anything to bring up to the floor at this time under old business? If not, going to new business. Cal?
We have case number 21-05. Justin Hinkle is appealing the demolition of 923 Ogant Street, Sandusky, Ohio, 44870, parcel number 57-03824.000.
Yeah, and we have a history with this property, actually. So that's why I provided a little bit of the background for you in this. The property owner is currently Florence L. Ritter. She was deceased as of February 2014. The real estate taxes are delinquent in the amount of $1,482.83, but is under contract for payment with the Erie County Treasurer. The last payment of $35 was paid on February 1st of 2021. A garage located at the property was demolished by the city in 2017, and the costs were assessed to the real estate taxes. Information from the Erie County Auditor's website showing ownership and delinquent tax information is submitted as Exhibit A. I think you all have that in your packet. And here is that information showing ownership under Florence Ritter. And there's the delinquent tax information. And there's the last payment there at the top made, looks like February 1st, 2021. The notice and order of demolition of the dwelling is being appealed by the grandson of Florence Ritter, Justin Hinkle, with an address of 428 East Washington Street, Sandusky, Ohio. The appeal form is submitted as Exhibit B. The appeal form states that the building official determined that the total percentage of the structural deterioration is 83.05%, and in accordance with Section 1341, 18D3 of the codified ordinances of the city of Sandusky, the dwelling located at 923 Ogant Street shall be demolished. The relevant points are listed as follows. Mr. Hinkle is going to do the repairs on the dwelling. That grandma is deceased, and Mr. Hinkle is looking forward to repairing the dwelling. And those were his words from the appeal form as Exhibit B. The city had received a complaint regarding the garage located at this property on December 3rd, 2015. The exterior of the garage was inspected by Code Compliance Officer Angela Katsopoulos.
I'm going to go ahead and place on the record that Miss Allison Will has arrived at 4:10.
A notice of violation was written on December 8th, 2015, addressed to the property owner, Florence Ritter, and mailed by certified mail on December 8th, 2015. The certified mail receipt was signed on December 12th, 2015, but the signature is illegible. The property failed inspections on January 11th and February 2nd of 2016 with no improvements done to the property. A lien search was ordered for the property on February 10th, 2016, through which it was discovered that Florence Ritter was deceased, and the probate estate listed Lori DeMore and Diane Lynch as her heirs. There was no real estate listed in the probate case. The transfer and death deed was filed for record on March 28, 2003. Erie County record number 200305473. This listed Lori DeMore as the beneficiary of the property, and the lien search is submitted here as Exhibit C. So here is the lien search. stating the transfer of death deed, the filing number. And there is actually the transfer on death deed. A notice and order of demolition for the garage was issued to Florence Ritter, deceased, and Lori DeMore, beneficiary, and was posted on the property on April 11, 2016. Shortly thereafter, Lori DeMore made contact with Inspector Katsopoulos, and Ms. DeMore stated that her sister, Diane Lynch, was living at the dwelling. The notice and order of the demolition for the garage was not appealed, and an affidavit of demolition was filed with the Erie County Recorder on July 12, 2016, and the garage was eventually demolished by the city. Unfortunately, Ms. DeMore passed away in June of 2016 while she was in the process of obtaining legal title to the property. After Ms. DeMore's passing, Diane Lynch, heir and occupant at 923 Ogons, advised that she was going to contact the probate attorney to see about obtaining legal title to the property. Although several complaints actually were received in regard to the interior of the residence, no action was ever taken due to the fact that Ms. Lynch would not grant us access, and at that point, code compliance ceased further efforts of enforcement to allow time for the probate proceedings to take place. We had no probable cause. Supporting emailed correspondence submitted as Exhibit D, and these are in your packet. I didn't put them up here. The dog warden complaint is how we actually gained access. So on October 29th of 2020, Brad Link was called by the Erie County Dog Warden's office to 923 Ogon Street regarding the death of a dog and the condition of the interior of the structure. Brad Link met with Deputy Dog Warden Shelley Graves and Andrea Kogar on site to do an inspection. However, the interior of the dwelling had such an unbearable offensive odor and was infested with fleas, and it was so cluttered that obtaining access was not feasible. They didn't even attempt to take animals out that day. It was that bad. The property was condemned immediately as unfit for human habitation and was ordered vacated. Pictures were taken of the exterior, and a few interior pictures were taken of the living room from the vantage point of the front door. These pictures are submitted as Exhibit E. I have to apologize. My throat's dry from talking too much today, so I'm trying to keep it moist. It just sounds horrible. This is the roof of the structure was severely damaged. Around the foundation, there was issues, but there was no gutters and downspouts on the residence. The eaves were missing, allowing for the elements to get into the attic. It was relatively kind of a hoarding situation with animal hoarding as well. From the exterior, this was the living room from the doorway, and that's the damage from the hole in the roof at that point. And there's the condemnation. On October 29th, 2020, Brad Link mailed the condemnation order by certified mail to Florence Ritter, care of the occupant tenant at 923 Ogot Street. The condemnation order was delivered by the USPS on October 30th, 2020. The signature on the certified mail receipt is illegible. A copy of the condemnation order, certified mail receipt, and United States Postal Service tracking report is submitted as Exhibit F. There is the condemnation vacation order and the mail receipt. And that's the tracking, just saying that it was delivered. It was left with an individual at that address. The Erie County Dog Warden made contact with Code Compliance Division on November 7th, 2020, advising that Ms. Lynch was allowing them into the residence to remove the cats. Previously, they had removed several dogs, cats, and rabbits. They advised that the house was somewhat accessible to perform a housing inspection. So Brad Link was on vacation, and Code Compliance Officer Dante Shipp and myself, Housing Manager Amanda McLean, arrived on site and performed an interior inspection on November 7th, 2020. A follow-up email from Deputy Dog Warden Andrea Kogar is submitted as Exhibit G. That's, for us actually to obtain the access. And the interior of the residence had innumerable housing code violation and was in such poor condition that the housing manager determined to ask the building official to inspect for a percentage of deterioration. Those pictures from that inspection are submitted as Exhibit H. There is the interior, ceiling, living room. And as you see, it was somewhat accessible, so you can't see it here, and I don't even know if we got pictures, but the flooring underneath of this was so deteriorated from animal feces and urine right there that it literally ate away the surface of the material. At the time, I asked Ms. Lynch where she was staying, and this is the area. It was a little desk that she had cleared, and she said she slept there. And this is the flooring in the kitchen. There is none. This is more water damage in the ceiling in the kitchen. And we were unsure if the plumbing actually worked. It was, we didn't get the pictures, but there was cat feces all over inside the tub and around. The water tank is older. And this is more mold and deterioration from the water damage. And that's the hole that goes into the living room. And this is more conditioning. We took a deeper look at the condition of the roofing. The foundation is crumbling. This is actually, I believe, upstairs. And we were trying to show that you could actually see daylight coming through. It was not watertight and weatherproof, although somebody had potentially been living up there. I believe she said her grandson at one time. Oh, that's what you see in that picture. Here's the daylight, if you see that through the... We were unable to get back to the access of where the actual hole was. That's about as far as we could get. So building official George Polis and co-compliance officer Brad Link inspected the dwelling on November 16th, 2020. Those pictures are submitted as Exhibit I. The building official determined that the total percentage of the structure's deterioration is 83.15%. The inspection report is submitted as Exhibit J. An updated lien report was requested from Fidelity National Title Company with Florence Ritter, found to hold fee simple title and no other interested parties. And that lien report is also submitted as Exhibit K. Here are these pictures from George. There seemed to be some substantial damage to that foundation due to the water damage. There's the inspection report, and there's the percentage at 83.15%. Title report still listing fee simple title and Florence Ritter. And then in accordance with Rule 4.4A1 of the Ohio Rules of Civil Procedure, the notice and order of demolition was posted once a week for 6 consecutive weeks in the Sandusky Register, giving notice to the heirs of Florence Ritter and any other interested parties having an interest in the property that they have the right to appeal the demolition order. The proof of the publication is submitted as Exhibit L. The notice and order of demolition was also posted on the dwelling at 923 Ogot Street on December 9th, 2020. Picture of that posting is attached as Exhibit M. And there's the proof of the printing. And there's the printing itself, the wording, as the notice to the heirs. There's the posting on the property. In the code compliance recommendation, the property is still in the name of Florence Ritter, deceased. The property cannot be mortgaged nor used as collateral for rehabilitation or repair funding unless the legal title to the property is transferred to a living person. In order to obtain legal title to the property, an heir must file in probate court listing the real property as an asset in the estate of Florence Ritter and/or Lori DeMoore due to the transfer on death deed. I actually had given Lori and Diane Lynch, the actual attorney who handled the original probate estate. That's the reason that statement is there. He was willing to help do that. The building officials determined that the structure is 83.5% damaged and or deteriorated from its original value. Section 1341-18D3 of the codified ordinances of the city of Sandusky states that when a structure is 50% damaged, decayed, or deteriorated from its original value, it shall be demolished, and is recommended that the Housing Appeals Board deny the appeal order and order the demolition of the structure for the protection of the health, safety, and welfare of the neighboring property owners and the community at large. And I don't know who's going to speak on behalf of the appellant. You are, Justin? So will you please step to the podium and state your name and address and who you represent for the record? And there's hand sanitizer here.
Good afternoon, everyone. Haven't been on this side of the podium with respect to.
You have to speak up.
I haven't been on this side of the podium with respect to the housing.
Speak louder than that.
Speak louder than that?
He has hearing aids. He has a hard time.
Frank, you're too young. I'm here on behalf of Justin Hinkle, who is one of the heirs per the notice in the paper, who is, and I believe you have been paying, are you the one paying the taxes?
Yeah, no, I'm going to be picking up payments on the taxes, but I did file a motion, like, to have this all put forward, and I'm the one that's going to be doing the repairs.
Yeah, hold on one second. We'll get to that in a minute. We just got, my law firm, Reminger, got contacted by Justin Hinkle through his aunt and uncle, Chris and Mary Romick, or Mary Mishler, in terms of what Justin is trying to accomplish with respect to this property. I believe he's the great-grandson, not the great-grandson of Mrs. Ritter, Florence Ritter, who is the owner of the property, and the great-nephew of Lori DeMoore, who has since passed as well. Justin is gracious to the city, and I did speak with the city with respect to their cooperation with Mr. Hinkle in terms of trying to get the proper, get in front of the proper people and advance this appeal. We're not here disputing the condition of the property at the time that the photos were taken. What we're here to do is basically throw ourselves at the mercy of the Housing Appeals Board and the city with respect to a game plan that I think will preserve a residence in the city of Sandusky and provide Mr. Hinkle with an opportunity to own his own house. Mr. Hinkle works for his father, Dennis Hinkle, who's a registered contractor through the city. I think it's DHI. He has construction and carpentry skill sets. He also has an uncle, Chris Romick, who has been responsible for revitalizing downtown. So he has support and backing. With us today, we have a timeline and a game plan if the Housing Appeals would be inclined to give us more time. More from having inside information with respect to how this works. Obviously, there's an appeal with respect to the preservation of health, safety, and welfare, but we know that even if the court were, or the appeals board were to deny the appeal process, by the time it gets to the commission and the house actually gets demoed, it'd be 9 months, 10 months down the road before an actual demolition takes place. The timeline that I believe Justin is going to present to you is that he can fix that property before it could actually get demoed up into a status of being code compliant and appealing to the eye. I think the question with respect to your vantage point into Amanda's point is that right now there will take some legal finagling in terms of getting the property and title in his name. I spoke with my partner, John Ball, who's a probate attorney, about 30 minutes ago. We would do a similar publication with respect to notice to all potential heirs when we file something in court. I've left a message for Lori Demore's, well, I guess it was her husband, because she died before they got divorced, but he has no interest in the property and would sign a disclaimer. We would publish it to the rest of the heirs, and we believe we can successfully obtain proper title within the next 60 days, or a little bit more than 60 days. It'd be like 75 days. But cautiously, and again, thanks to Amanda's advice to Mr. Hinkle, he was going to begin the process of improving the property. However, none of us wanted to be in a situation where he put, 10, 15, 20 grand of his own money into the property that he doesn't have title to, and then the Housing Appeals Board inevitably makes a decision to demolish the property anyways. So we're here today to basically ask for more time. I do have, can I give this to you too?
Sure. State what it is, and we'll put it on the record.
So what I'm handing you is basically a repair plan and cost estimates to what Justin has indicated it would take to get this property up to code, including construction to the exterior and interior of the property. Briefly, off record, we talked about his timeline, and he had an exterior completion date of August for the exterior and November for the interior, but I told him, I think, based upon the conditions of the photos, and I think he agrees that it's probably the interior should be tackled first versus the exterior. So that would be the only amendment to that, but we believe by November, you could have all of the,
I can have it all done.
all of it done. The other thing that we're asking, I guess, and it could be some sort of agreement or stipulation, but we would consent to a waiver of any appeals rights to the decision that you guys make at a time in the future pending those repairs, meaning if we don't complete the repairs by X date, he would waive any right to appeal any decision of this board and consent to the demolish of the property without, and basically waive any rights that he would have to appeal it to the common pleas court. More like a stipulated settlement agreement. I don't know if you have anything to add.
I just wanted to give a little bit of information, just a little insight in on this house. This house was built in 1913. My great-great-grandfather built it. And I can remember going there when I was a kid, and whether we was doing laundry or just going to visit our aunt, our grandma, I can remember going there, and the times that I spent with my family, I don't want to let that go. And I'd like to help some of my family members out, like if I was given the opportunity to remodel this house and get it up to code, get it to be basically like it was mentioned, it was an eyesore, and that's understanding. But the people that had the house, my family that had the house before, they really didn't care about self-image and such things like that. But I would actually make it to where, I mean, it'd be fully livable. It'd be it wouldn't be an eyesore. It'd be a part of the community, and it would raise, like, I don't know, it'd just make a statement like where someone can see basically the glass half empty, and then someone else basically perspective, how you see things, how your outlook is on it. Like, you would look at that house and think, okay, there's no possible way. But in my line of work, that's like, when you see that, it's like, okay, you might see something that's impossible. I'm gonna see something that's impossible and turn a negative into a positive. I see great potential in that house. Maybe because of my background, maybe because what it means to me, but I would give forth the effort and time and to make sure that it's completely remodeled. And I have the financial abilities, and I got great support systems. I have good knowledge. I have good knowledge on how to repair the home. I have good knowledge on painting, construction, carpentry. I have skills, and I think I have the potential to make this a great living home, and it could benefit the community. I mean, as well as helping me out. I mean, not that would be. Sorry, that's my name. No, not that that's like, I don't know, top list on everybody's day, but look back, I just kind of come from nothing. I'm just trying to help my family out here.
Thank you.
And as you know, our code provides for a variance. Section 1341-07B of the codified ordinances provides that the board shall interpret the intent of this chapter in specific cases where on appeal it clearly appears by reason of special conditions. Undue hardship would result from the literal application of any section of this chapter. Where undue hardship is clearly demonstrated, the board may permit a variance from the applicable section if the dwelling will vary only a reasonable minimum from the literal chapter, but will comply with the spirit and intent of the chapter with respect to sanitation, safety, and rehabilitation. If the board decides to grant a variance, code compliance strongly recommends that the owner meet all of the conditions set forth on the next slide, and if at any time, any one of the conditions of the variance are not met, the Housing Appeals Board shall revoke the variance, deny the appeal and order of the demolition of the structure. The variance requirements: before construction or rehabilitation commences, title must be legally transferred to Justin Hinkle. Comprehensive rehabilitation plan shall be approved by the city chief building official, and any changes to the approval of the rehabilitation plan shall be submitted and be approved by the city building official before any changes commence or constructions takes place. I'm sorry, I'm getting really old because it's really hard to read the small print. A professional estimate of the total cost to the rehabilitation of the structure in order to bring it into complete compliance with the Ohio Residential Code and the Building Code and the codified ordinances of the city shall be provided. Proof of financial capacity to complete the approved rehabilitation plan shall be provided. All required building permits shall be obtained. And during construction rehabilitation of the structure shall commence immediately and proceed with due diligence until completed within a time period deemed reasonable by the Housing Appeals Board. Certified contractors shall perform the rehabilitation work as required by the Residential Code of Ohio and/or the Ohio Building Code and the codified ordinances of the city. Rehabilitation of the structure shall be completed in accordance with the plans approved by the chief building official, and any changes to the rehabilitation plan shall be approved in writing by the chief building official. A code compliance officer shall be granted access to inspect the interior of the structure on a monthly basis in order to report progress of the rehabilitation project to the Housing Appeals Board.
Oh, well, it scared me.
So where do we go from here now?
Floor is open for discussion, questions, anything.
There.
I do,
Floors.
I want to know if you guys understand too what Justin said by waiver of appeal. That if you grant this variance, and no matter how much money or time that Mr. Hinkle puts into the property, if he does not follow your guidelines, they will not appeal your decision and you can order demolition and proceed accordingly. Is that correct, Justin?
Yes.
Okay. What's the wishes of the board?
Well, I think this whole issue comes down to one fact. In order to proceed, you need to be the owner.
Yeah.
Are you the owner?
I'm not currently, no.
They're in the process.
I'm here. I'm in the process.
I'm curious,
Do you, Commissioner President, we are in the process, I mean, literally, we got this case yesterday. We talked to John Ball.
okay.
He's an estate probate attorney, well-known in the community. He thinks this is simple. I mean, one of the simplest probate issues outside of publication and disclaimers being signed by family members who we believe will sign it. We can have ownership within 75 days.
Well, my question is, when were you notified by Mr. Hinkle? When were you asked to represent him?
In all fairness to Mr. Hinkle, I was actually, he attempted to reach out to me about a month ago, but my stepbrother passed away and I was in trial, so I just am now. And then I didn't know exactly the scope of this case until I got all the documents yesterday.
I don't know, to me, it looks like there's much more extensive damage to this structure that's going to require far greater than $10,000 of rehab.
Yeah,
But I mean, that's up to your contractor.
Understood, yeah. Well, the funds, they can, that can be adjusted. And I'm sure I have access to more than $10,000 for the exterior, or for the interior and the structure. The structure was a main concern because 83%, that's basically the whole house, understood, but, I've done repairs and reconstructions and remodels of homes that like the floors are, I mean, like the damage to the house, like you said, the structure, I've repaired this before. I've gone through the steps that it takes. That's why I see it. I can see the steps that need to be done, and like I can walk it. I know everything needs to be done from the start to finish.
With respect to this variance, you can revisit the variance at different increments, and you guys can check the variance back in 90 days, right? And you can grant the variance today, 90 days from now, review it under old business. At that time, he should have ownership of it. He should have submitted a contractor's proposal that basically spells out all the costs associated with building it up to code in conjunction with the chief building official and sign off and approve. He can't commence work until the titles are transferred to his name per the variance. And at that time, you review it in 90 days. He hasn't done that. You hammer the gavel and just put it in line to be demolished. All we're asking is basically 90 days of time to give you guys a solid game plan and process to move forward.
Yeah, that was going to be my question.
I'm
We do
curious.
this in increments.
I'm curious about the simple, quick process of probate, if it is such. Why has it not happened?
Because he's not an attorney.
Yeah, and if I could speak to this, actually, when Diane was living there, I know that she was on a limited income. We had no idea. We didn't get into the property, but that is why code backed off, because we thought it would be very simple for her to get get that in her name. Even with Lori DeMore passing away, I think, correct me if I'm wrong, I think now, though, it may be a little bit simpler.
Correct. And Diane was there, and if if you look at the citations and when she actually allowed access to the property, that's December of 2020. That's theoretically only 4 months ago. And he stepped up to the plate. They advertised 6 weeks in December. He filed the time to file the appeal. I think from his involvement in this whole entire process, the 2016 photos, 2017 photos, 2018, 19, none of that is his involvement. This is him as an heir per the city advertising to all potential heirs, him reaching out to his potential family members who have any interest in the property, none of them saying they have any interest or stepping up to the plate, and this young gentleman stepping up to the plate. Could it have been sooner? I think it could have been, 30 days sooner, but for me, yeah. Oh, yeah.
Okay, that's why.
Anybody else?
So if we can do the,
Gary?
in steps of the variance, I'm kind of in favor of that. I don't know what the board thinks.
There's one other comment I wanted to make, and whether it has any real important bearing on this or not, the property taxes are based on a homestead exemption, which wouldn't apply any longer.
The $1,400 efficiency.
The $237.57 per half that's being withdrawn because of a homestead exemption that isn't in effect. Is that right?
Yeah, that's correct. But that can't be corrected until ownership transfers, and it would be kind of foolish to make any more payments until we know the status. And that would be correct. So, but even once he gets it in his name, that takes a full year to take effect before it actually will go into the normal taxation process, because our taxes run a year behind.
And any transfer of property through probate, it's subject to any and all tax liens. So, I mean,
What's the wishes?
I yield to whomever else wants to speak.
I'm going to have to abstain from this. It's another house I have to abstain on, unfortunately.
You want to say something, Allison? Looks like you wanted to.
Speak up, kiddo.
I guess my question would be, even on the foundation, where you have 1,800 or 18,500 was your estimate for interior and exterior. And I understand you're doing the work yourself, so it's basically just materials.
That's what that wasn't the cost of labor.
No, it's just materials, because you're doing it on your own, so obviously, yeah. And I guess my concern would be with that estimate, but would there be a more detailed estimate?
Yeah.
Because my experience, just because we do a lot of repairs to rentals, that it seems like it could be upwards of even twice to 3 times that amount in reality. And just the foundation work alone would equal the probably 10,000 or 8,000. And I'm assuming you can't do the foundation work yourself. You do foundation work, like you've done that before?
Foundation, not.
Yes.
Can you speak up?
Masonry and foundation work, no, not fully. I don't fully understand it as far as I'm sure you need an engineer. I don't know, you might not, but.
yeah, through you, Commissioner President, Commissioner, what we will do, his estimate was just more in terms of when we were preparing today, at the 23rd hour, I said he needed some sort of game plan to set forth before it. The variance that we're asking for will be submitted actually by he works for DHI, but it would be from the actual registered contractor. It would be from either his father who owns the company will have more of a detailed pricing for the renovations.
And that is required by our recommendation for the variance, that the first step would, he gets title, second step would be to get the building official to approve plans with the cost estimate. So he knows exactly what he's into at that point before he begins any rehab.
Yeah, the CBO, I don't think would sign off on that.
And we feel 90 days is enough time to do both of those?
To get title and submit the proposal to the CBO.
Any other comments? Okay, what's the wishes of the board?
I'm looking at, does it have to be worded in a special way? Because
Tell me if this is what you are proposing, that you will grant the variance in increments, and the first step in the variance is that he must obtain title to the property, obtain plans, comprehensive building plans that are approved by the building official and submit financial documents within 90 days.
I wouldn't mind making that motion. I have a problem with the word increments, because if they don't have that, we're going to order demolition.
And in return, Mr. Hinkle is going to waive the right to appeal the decision of this board, and everything else will be based on the recommended requirements of the variance in step-by-step increments as
Okay.
the board sees reasonable.
So I would make that motion.
I just have one comment before I say anything else. I would hope that the acquisition in your name happens much sooner than 90 days, since it's a simple process, okay?
Yes.
I will second that with the understanding that everything that happens in that variance, you must meet.
And if not, we're going to order demolition.
Okay, there's a motion on the floor. All in favor signify by saying aye.
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 Opposed?
Mr. Frank Valley,
I abstain.
Roll call.
Mr. Fraser,
Frank Valley?
Abstain.
Miss
Conflict of interest.
Janice Warner,
Aye.
Mr. Gary
Yes.
Gunsberger,
Yes, aye.
Ms. Sharon Johnson,
Abstain.
Ms. Allison Will.
Aye.
What's the count?
32.
3-0. Okay, motion passed. Anything else for Brother Cal?
Nope, we have nothing new.
Okay, the
I
floor.
move for adjournment.
Second.
I haven't got a second. All in favor signify by saying aye.
Aye.
Did you guys give?
Meeting adjourned.
90 days.
Okay.
I'm gonna bring it back then and
Yeah, 90 days.
Okay, gang.